Thank you very much, and Mr. Yadav, and good afternoon to all of you. Mr. Venugopal, the Attorney General for India, Mr. Rakesh Khanna, President, Supreme Court Bar Association, Mr. Yadav, Mr. Sharma, our very, I would say, a new face and very welcome face insofar as law officers are concerned. ASG Diwan, and Mr. Datar, who is expert in all fields. I was thinking that when this topic of directive principles was discussed and these lectures were delivered, Mr. Datar must be thinking that, oh, this is my topic as well. But he is expert in the topic which we are going to address. So therefore he'll be equally at ease, I know. Let me at the outset thank Mr. Rakesh Khanna for giving me this opportunity. And what a coincidence that as far as officially in my present capacity, this is going to be my last lecture. And he very much wanted, about a month ago, I think we had discussed, but somehow the things got delayed. But at least and at last we are here. As he said that I chose the topic on this law and economics, when he said that you should give a lecture after Chief Justice gives, because it was initially designed that first week he will give and next week I'll give. But then last week I think it couldn't happen, and that is why these two programs are consolidated. Yes, in the process suggested this topic because I was thinking that this is one area where subconsciously in decision making, economic factors are seen by the judges or are impressed upon and argued by the lawyers, but there is no direct discussion on this aspect and conscious effort as to how the economics can play a role in decision making. Let me tell you, it is not something which is totally new. Yes, it may be new insofar as this country is concerned, but if you talk about the word scenario, it was way back in 1850s, Adam Smith and David Hume, they conflated the law and economics in their works. And Bentham also had talked about it. But then thereafter, for many, many decades, or maybe a century, it remained dormant in almost all jurisdictions. It was in 20th century and after 1950s, or particularly after 1970s and 80s, that it surfaced in this kind of approach, economic approach or approach of economic analysis while deciding the cases in US. And the persons, the scholars who were economists as well were Ronald Coase, Frederick Hare, Gary Becker, and there are some legal scholars like Calabresi. They have written tremendous amount of work. Much of this I have read as well, including one Court of Appeal judge, Judge Richard Posner, who demitted office a few years ago, and he remained judge of the court in US courts for almost 35 years. And Coase and Becker, let me tell you, they were even awarded Nobel Prize for their respective works. Now, this mainly the idea thrived and when the Posner had written so many books on this. If you see, whenever we, in our jurisprudence, as students we have studied, and in courts every day, when we talk about the interpretation of statutes, or interpretation of various provisions of constitution also, and various jurisprudential theories of justice and other theories as well, we would normally will talk about law and morality, will talk about this theological or philosophical approaches to law and how these should be interpreted. But there has not been much up to now insofar as relevance of field of economics in law is concerned. And here they have, all these scholars, I mentioned these names, they have talked about the economic aspects of law as well. Now, the first question, therefore, in this scenario is, what is law and economics? Or what is the relationship between law and economics? Or what is, if I phrase it more appropriately, what would be the economic analysis of law? And as the name indicates, a theoretical analysis of law based on principles of economics. The overarching principle being efficiency and rational choice theory. Now, this is the theory which is much prevalent in economics. Those who are the students of economics, I am, and they would be knowing about it. So, in that context, it examines legal rules as a set of incentives aimed at bringing about the desired social interest. So these are the economic rules which are brought, and in that sense, if you see here, in the economics, it is said, and the presumption is what we call that every person is a rational person, and whenever some choice is given to take a decision in economics per se, it will be a rational choice depending upon what is in my favor and what should I do. Even if you go to market and you want to buy a particular product, you will see various brands of that particular product. You will see what is the quality of that product and what is the price attached to that. Naturally, you may pay even a higher price, but if you feel that the quality is better. But you will always try to get better quality product with as less possible, by bargaining, etc., as you can. So this is what rational choice is, in nutshell, if I tell you. And so this is, choice is based that, and the economic analysis or economic theory says, to maximize the individual satisfaction. And from this follows the other theory, which is the counterpart of it, and this is called social efficiency. And the social efficiency is the economic state where there is an optimal distribution or allocation of resources, minimizing waste and increasing the net value of resources. That is what the consideration would be with every person who wants to set up a business or every person who wants to set up industry. And this, I'm just now telling about these basic economic principles, and how when you apply such principles in decision making, and in the process you think of the maximum individual satisfaction or societal satisfaction, that particular kind of outcome, and that is, we are introducing here now the element of economics into the law, if in a particular given case we do that. And for this purpose, actually this analysis can be of two types, as the scholars have said, and depending upon the questions which we need to address in a particular case. On the one hand, a descriptive analysis of legal rules which deal with the effect of legal rules on relevant social actors, and is used for explaining and predicting how people act under various legal constraints. We know that. Actually, there's a very interesting book. It is called Freakonomics. And yes, Freakonomics by this Edwin. Let me tell you his full name. It is Stephen Levitt and Stephen Busner, two authors they have written. And a very interesting theory which they have developed is that all crimes which take place, again we are talking about law and criminal law here, all crimes which take place in the society have economic factors behind it. And they have analyzed in the entire book, and therefore they have said, if we keep in mind the economic factors and we try to eliminate those, there would be no crime. And the authors, I had read this book about 10, 15 years ago, but they have come out with another second edition also. It's not second edition, rather another volume also on this book, which is called Super Economics. And in that book, if you see the manner in which they have tried to, it's not that it's only a theoretical discussion in the book. They have even tried to demonstrate in America by taking particular projects, when these were the situations, what was the crime rate and how it came down. And it's very interesting. Because of paucity of time, I won't be able to go into all this. But then, when we talk that this is the economic analysis and how it is to be done, of course, let me now try to tell you in somewhat easy words or in easy manner, in the context as to what is the role of judge and how the judge are supposed to apply these principles. As the last topic itself shows, that India is a constitutional welfare state. We have been talking about this welfare. And one of our most important social goals is the social welfare. So since our country is in road of economic growth, economic welfare and well-being of the citizens, especially the most vulnerable sections of the society, is an indispensable part of social welfare. All the wings of the state, the legislature, the executive and judiciary, should therefore take measures to ensure that this goal is achieved. The legal regime in our country is already moving in that direction. If some of the recent laws, and when we talk of ease of doing business as well, are, if you see, insolvency and bankruptcy code, they entirely based on economic considerations, even real estate regulation and development act, and the constitutional amendments which are incorporated to bring about goods and services act. There's, at the back of this, there are total economic considerations. And in one of the judgments in Shiv Shakti Sugar Limited, the Supreme Court had said so while applying this principle of law and economics, that the judicial wing, while undertaking the task of performing its judicial function, is also required to perform its role in economic growth. It calls for an economic analysis of law approach, most commonly referred to as law and economics. The first duty of the court is to decide the case by applying these statutory provisions. Because we have to decide the case as per law. However, on the application of law and while interpreting a particular provision, economic impact or effect of a decision, wherever warranted, has to be kept in mind. Likewise, in a situation where two views are possible or wherever there is a discretion given to the court by law, the court needs to lean in favor of a particular view which subserves the economic interest of the nation. Conversely, the court needs to avoid that particular outcome which has a potential to create an adverse effect on employment, growth of infrastructure, or economy, or the revenue of the state. Now, take for an example, and it was said way back in Ronak International judgment as well, in the context of when the public project which is coming up and a PIL is filed, or even a tender which is awarded and the award of tender is challenged, and the stay of the project in the meantime is sought. Whether the court should grant that stay at that time or not, and in that case also the the division bench said that look, although may not be, as I said, subconsciously these considerations are kept in mind, that if the project is stopped today and if after 1 year or 2 years the petition is dismissed, what is going to be the impact of this public project insofar as economic considerations are concerned? If suppose the project is worth 1,000 crores today, and after 2 years or 5 years, the cost may escalate to 2,000 crores or 1,500 crores. So therefore, whether today we should grant that stay, that these are the economic considerations which come in mind and which have to be kept in mind. Yes, as I said that in the first instance, statutory provisions are to be kept in mind. Suppose in a particular case it is found that the basic procedure was not followed at all. Suppose take an extreme case where the contract is awarded without even inviting tenders, and that is not followed. Yes, then the court may not look into those consequences. But if it's a tribal issue which the court has to go into, and the procedure is followed, and the court has to scan through it whether it is right or wrong, but in the meantime, what steps should be taken? So this is the economic consideration which come into mind. I give you the example of it can be in various laws. I tell you, I have a very detailed paper. I will not be able to say everything. I'll give the paper to Mr. Khanna. It can be circulated or put on your website. But take the example of Land Acquisition Act. Now, why new act in 2013 was enacted? Because we saw under the old act, whenever land is acquired, whether fair and reasonable compensation is given or not, that is the economic aspect, because the person who is divested of his land wants full compensation or adequate compensation so that he is able to buy some other property if he is divested of his agricultural land or maybe house property, etc., whatever. So, but why it led to the litigation is that every time the person whose land is taken away would think that they are not adequately compensated. So therefore this new act of fair compensation, and if at that stage what is realized now is that you enter into an agreement or tell him and take his consent and then take over the this land, there may not be much litigation or much problem in this. IBC, I have given the example how it is explained. Even competition law is entirely based on economic analysis. But take, for example, intellectual property matters. Now, when intellectual property matters come, suppose it's a matter relating to infringement of trademark, and a suit is filed, where plaintiff says that defendant has infringed his trademark. There may be a clear case of counterfeiting, that I am putting a label of Calvin Klein and therefore selling under the name of Calvin Klein, which I can't. So there can be an injunction straight away. But question is whether I have copied the design or this trademark is deceptively similar, etc., and there is a genuine dispute. Now here the question comes whether when the suit is pending and it is still ultimately finally decided whether there should be an injunction, a temporary injunction or not. Here, when we talk of balance of convenience or prima facie case or irreparable injury, according to me, complete principles, economic principles have to be applied. One case came before me when I was in the High Court of Delhi. It was a case under Designs Act. Pearl Pet, you know, is a very famous with their bottles, etc., and they had filed the case. The defendant was saying that I have not copied the design, but it was again a genuine serious dispute whether he has done it or he has not done it. What ultimately, after analyzing that, prevailed in my mind, which I had written in that order also in the High Court. Look, here defendant is not a fly-by-night company. It was having its industrial setup, a big industrial setup with maybe 150 to 200 persons who are employed there. He had invested 15 to 20 crores in that project. Now the question is, if you grant injunction today, then what happens? Not only he had taken loans from the bank, so not only he will not be able to service the debt, 150 persons would get unemployed. As against that, if ultimately plaintiff succeeds, then plaintiff can always be compensated in terms of money. So therefore, these economic factors even in IPR laws would come. Another very interesting thing, and then I'll stop at that, because as I said, there are so many other things I'll give, that even, you see, when we talk of economics, from litigants' point of view, I'm not talking about the access to justice, a totally different aspect on which I'm going to write in near future. I'll get time also now. This is an aspect of mediation, that there is an economic element behind it. When a person is to choose his remedy, that what kind of suit he should file, the advocates think There may be a case where there may be some element of criminality. So they'll file that criminal case against the person instead of filing a civil suit for recovery. They may file a suit of cheating, etc. Going by these considerations, I may not have to spend much money. At the same time, there would be more pressure on the other side, and I may get my money immediately. These are economic considerations. But then the best economic consideration to advance mediation is that it is the least cost bearing. That has to be propagated, and that is why people may be going, and in many statutes now, this is becoming a provision is made, and it is made compulsory, this mediation. So even behind the success story of mediation, there may be this, if we adopt the economic principles, it may bring desired results. There are certain exceptions to the economic analysis of law. As I said, that it depends upon altruistic behavior, it depends upon the rational behavior of a person. But then there are certain persons in this society which go by altruistic considerations. They may not go by economic considerations. And therefore, now take for example, this education, healthcare. Then in these cases, whether it is one can go by total economics, I think it may not be. Take the example which comes to my mind is in the case case of patents, that Navratri's case, where life-saving drugs which are required. Now, court has to keep in mind the interest of the person, the patients who have to get these life-saving drugs at cheap rates. And that was in the mind of the court, I feel so, although it is not so stated, but one can easily make out. It was in the mind of at the back of the mind of the court that, look, if we protect this patent of a multinational company, drugs in this country may be much, much costlier, which our people may not be able to afford. So while interpreting Section 3D, the court interpreted in such a way so that no harm comes. Here what I'm trying to say is that sometimes insofar as human rights aspects are concerned, there may be some conflict between the economic considerations on the one hand and human rights. Take, for example, environmental laws. Now, many industries are banned. It was in 90s and 2000, early 2000, Supreme Court banned many entries in scheduled entries in Delhi. But then one could say that, look, it has adverse economic effect. Production goes, unemployment increases, etc. But in the interest of the health of the people, this had to be done. But very interesting case came before me, which I can say, and Mr. Dattar has also been appearing in that case of firecrackers. Now, here it was argued that, look, many would be affected. Here I am talking of that particular, and I'll give one or two examples on that, and for you to decide, where the effect of that particular, the environmental effect, it is not necessary that it is because of that particular item only. As it was argued that, look, if air is polluted in Delhi or elsewhere, it is the firecracker is not the sole cause, which is correct. Now here, but it contributes. This is also correct. The question is, on the one hand, we have, yes, 5,000 crore industry in Tamil Nadu. There are thousands of people employed there, is on the one hand. But then, as against that, if there are ill effects on health of those persons, if it is polluting the air, what is the cost of health? Here there is no data. I indicated in my order and left it at that. So economic analysis, while working out this, there are three elements which come. Human rights on the one hand, then employment and the rights of the industry, and on the other hand, and cost of health on the other hand. All these have to be worked out. That's why I said I indicated and left it that, because in the absence of any statistics, you could not do so. Another case which came before and which has been subject to some criticism is this on highways, these liquor shops. Now, question is, on the one hand, we are banning those liquor shops, because what is the interest involved as per the court? That many road accidents take place when the drivers drive under the influence of liquor. But question is, when we take up economic analysis, because by banning it, you are naturally stopping, or you are, closing so much of shops, etc. there, and unemployment, earning of those people is one economic factor. On the other hand, what I feel is the study should be done, how many accidents take place because of that reason. If that's the sole reason, yes, human rights would prevail. But if that is not the sole reason, then how many accidents take place because of that reason? This is the study which has to be undertaken. Another example I give, when for environment, 2000 CCC cars above 2000 were banned. Now again the dispute was, and it was argued by the car manufacturers, that the pollution to the air because of this 2000 plus cc cars is minimal, or there's hardly any, point something. So therefore, on the one hand, if it is not making a major contribution, can you ban the this production and sale of the cars, not production, at least sale of the car in this city, only because of this reason, which may have economic factors? So there's any number of examples of this nature, and I feel that it is high time now the courts should take into consideration the comparative analysis from economic point of view, and on that basis these cases should be decided. Thank you very much.